However, because I am from Guatemala and I understand that is a mouthful of letters, you can just call me Maria Cordon with a C, or like Gordon, but with a C. I am here to present on the differences between the Chapter 7 and the Chapter 13. I'm very happy to be here on by invitation of Texas Legal. Texas Legal is a statewide nonprofit legal benefit plan that was founded by the Texas State Bar and the Texas Legislature in 1972 as an effort to better meet the needs of Texans. Texas Legal provides members access to over 500 network attorneys, and Texas Legal offers various plan policies. Contact information will be in the comments and a description on the box of this webinar. With Texas Legal, members covers legal matters such as bankruptcy, Chapter 7 and Chapter 13. The only fees members would be responsible would be for incidental costs, for example, filing and notary fees. Texas Legal has you covered as long as you meet the 3-month waiting period from the policy holder's effective date. Today, you will be introduced to the differences between Chapter 7 and Chapter 13 and how utilizing your Texas Legal Plan benefits can assist you in determining the steps for your particular legal matter. So a little bit about me. First of all, I started practicing law in 1994. I obtained my law degree from SMU and my undergraduate degree from Duke University. I started my first job out of law school when I graduated in 1994 was in business bankruptcy. I went to work for a business AB-rated law firm, and so I was exposed to a lot of business bankruptcy. Then I also worked for another firm that did real estate. The partner, the owner, was board certified in real estate, and I got to experience firsthand the intersection between real estate and bankruptcy law in a business setting. The reason the person had initially retained me was because I had interned for Judge Solis in the U.S. District of Texas, North District of Texas, and he wrote me a fabulous recommendation letter. And so this is how I kind of went into bankruptcy and obtained some background knowledge. Then in 1999, I started practicing consumer bankruptcy. Consumer bankruptcy is the bankruptcy that deals with debts from personal, family, or household. It doesn't deal with business debts. So for a bankruptcy, a Chapter 7 or Chapter 13 consumer bankruptcy, the debt has to be at least 50% consumer. So I love helping people with their financial situation. Very much like divorce, bankruptcy is something that you can think about, maybe not do, maybe not. Some people want to get a divorce and they just never do it. They just want to talk to a lawyer about the possibility. So a consultation with an immigration or a bankruptcy consultation is not uncommon. Some of the questions that I ordinarily get, more so last year than this year, have dealt with the intersection between bankruptcy law and immigration. I encourage people to have a consultation or do a consultation before filing, just to get an idea of how you need to organize your life. In addition to that, Texas Legal has given me at least 2 boxes of goodies so that if you have a consultation with me, you also get a complimentary due to Texas Legal. Um, uh, for example, a Starbucks card or notepad or a coffee cup. And so you just, once you finish the consultation, you just tell me, what's in the box today? And I just look and tell people, hey, this is compliments of Texas Legal, who does, by the way, an outstanding job of supporting members and attorneys. And this box is a very thoughtful way of showing people how much they, care about them and have them think about Texas Legal. Also, Texas Legal, since I have been doing bankruptcy on and off since 1999 as a provider attorney, has been so awesome with me. They have always, I've never had a problem with anything. And I want to especially thank them for the opportunity to present today, because this is my first ever live presentation using this live stream media presentation, and they have been so supportive so that I could make this presentation and be live on camera and be on, fairly comfortable doing this. So I want to thank everybody at Texas Legal, not only for the support I got on this occasion, for inviting me to make this presentation, but also for all the little details that they take to make people happy. And so Texas Legal will pay for your attorney's fees and also for your consultation. And the consultation is also included in your membership package. So I really do encourage people to consult rather than wait until the last minute. And why am I saying that? Sometimes you are considering filing for bankruptcy, but you haven't. And some reading materials about surviving debt are helpful. Even though that is not the topic of my presentation, I would like to let people know that there is a booklet called Surviving Debt that is published by the National Law Center for Consumer Law. The cost is $20 and it's available. I don't get a commission, but I love them. I am a fan of that organization. And so if you are considering bankruptcy, but you want to also look at alternatives and you're not quite ready for a consultation with an attorney, that book is amazing. It's a booklet. You can download it, $25, and you can see how you can prioritize debt. And bankruptcy is one of those alternatives for surviving debt. And that I, encourage people to read when they have a minute, just to clear some of the questions in that publication are very are common, and you may not need to consult an attorney about bankruptcy before you explore other options. So what some of the questions that I have gotten, because I am board certified in immigration and nationality law since 2003, I deal with the juxtaposition between immigration and bankruptcy. There are not that many topics where there is that type of common where there is that common link. One of them would be in, for example, last year I was saying that I got a lot of questions because there was a law that dealt with the public charge of inadmissibility, and you had to show that you were self-sufficient. And it was a regulation that was based on that code section, Immigration and Nationality Act of 1284, which required ask people if they had ever used public benefits, if they had ever, and only some immigrants that were required to apply for a green card were in that category, mostly family and employment based. And they asked people questions about bankruptcy. So the form itself, the self-sufficiency form, dealt with questions on Chapter 7. They asked questions about if you had ever filed Chapter 11, Chapter 13, but they never mentioned Chapter 12, which I thought was odd because they used the normal chapters that are in the Bankruptcy Code are Chapter 7, which is liquidation, Chapter 13, which is wage earner plan, Chapter 12, which is family farmer, which is a hybrid between consumer bankruptcy and business bankruptcy, and Chapter 11, which is individual business reorganization. And for some reason, they just left family farmers and fishermen out of that form. The form just in this year, they stopped asking for asking people to submit it or adjudicating. That happened in March of this year. And one of the things that is important about law is that you have to have some warning about the law before it gets enacted. Before, it used to be that if a person filed, and I'm not going to spend too much detail because hopefully that was very litigated and it never will be put in place again. But it caught everybody off guard because if you are doing something that will take points or give you demerits on an application, or considered to be like, okay, well, maybe you'll be a public charge. It used to be that you would not be a public, that none of that would come into play until after you got your green card. And here, all of a sudden, things that were never before, it was not even like for people who file. It's like retroactive, have you ever filed? So that, I got a lot of questions on that. And the only current questions I have, two or three. One of them is like, have you, when you're trying to pay for filing your for your citizenship, they now ask, well, are you current on your taxes? So they only consider payments from the IRS to be to show that you are, if you're behind on your IRS payments. But also you can be caught up or be making payment plans with your taxes on a Chapter 13, or liquidate them altogether if the what I call, if it's the right age and condition, if your tax returns are of the right age and condition, you can also discharge them in bankruptcy. But it just the instructions for the application for citizenship only states that you have to show a letter from the IRS. So because I have never actually had a client where that was an issue, they were in Chapter 13 and also applying for citizenship. It's just one of those things that people ask me and I tell them, I would just be current and not worry about it, or just wait a little bit. So, or the other question I get sometimes is, well, will filing for bankruptcy affect my status and what? And this is just a common question that I get from people. I just have a preference for money orders. When you pay by money order, that money is already out of your bank account when you file for bankruptcy, it gives you an enormous amount of peace. You definitely don't want to be filing for bankruptcy and also putting your filing fees on a credit card. That's a no-no. If you are thinking of filing for bankruptcy, you need to put your credit cards away. When you file for bankruptcy, everything that you own, whether you have attempted to protect it or not, goes into a bankruptcy estate. So if your filing fee was $725 and the check hasn't cleared the bank, that money is the property of the estate when you file for bankruptcy. And if you had played with a money order, then that money would be out of your checking account and consequently not even have anything to do with being property of the estate. So I always tell people, well, things happen, but always pay your filing fees with a money order. And I don't even sell money orders for the post office, but for $2, you get a lot of peace of mind. And some people are past the place where they're just thinking about bankruptcy. They've been sued. And so I had already discussed a little bit about the booklet Surviving Debt, which describes the alternative to surviving debt, not through bankruptcy. If people have been sued and they come to my office, I am very happy to file bankruptcy for them. In addition to giving them the opportunity maybe to litigate it or something, but sometimes you may not have such a good case, and the sooner you file, the better off you are. There are 4 words that I have for people. One is lien, the other one is writ, the other one is levy, and also writ of attachment, which can be filed even before you lose the case. So, I'm just a fan of bankruptcy in the sense that if you don't have a really good defense to the lawsuit, I just encourage people to file. And I say this even though when you get sued and you live in Texas, Texas has really good protections for your property. You can have the Texas Property Code is super generous. It allows you to keep one home that hopefully you have homesteaded. And it allows you to keep up to $50,000 if you're single and up to $100,000 if you are a family. Many states don't protect us nearly as much property, and Texas is very, very generous with their exemptions. So if you are sued and you don't file for bankruptcy, you can always say, well, the sheriff can, pursuant to the statute, come 41. No, 3. Hold on. And then 42, I believe. So 42001, the personal property exemption, states that if your landlord is trying to repossess or has a landlord's lien, they can get everything but the family Bible or other writing. And so, yes, there you have property, but you can also get it exempted. Section 42001B of the property code says that, I already mentioned that you can protect your property, and then whatever property is not protected that exceeds that amount, the sheriff can come with a proper writ and execute on it, and you pick and choose what it is that you want, and the sheriff and the sheriff's sale can sell the rest. So those are protections that are founded. The Texas real estate provision that allows a sheriff sale is Texas Property Code 41001C3. So even though you can protect your assets with when the Texas Property Code, I feel prefer to protect assets with the Bankruptcy Code. If you file for bankruptcy, the most how it works is a little bit different because you have to be what exemptions apply to you have to do with domicile, and that is found at 11 USC 522B3, which determines if you have previously lived. It's a formula where if you have previously lived in such and such a state for so many days, then those exemptions apply. And so you look at what the domiciliary exemptions are, and then you use those applicable domiciliary exemptions and protections to protect your property. You can change your exemptions from federal to state, back and forth until the case closes. Once the case closes, you have to reopen the case and pay the filing fee in order to change your exemptions. And at the point where the case has closed, you have to give the judge or the court a very good reason why you are reopening the case. So whatever you do, you should do it before the case closes, including changing your exemptions. You cannot mix and match. You cannot have Texas exemptions and federal exemptions. You have to choose, but you can change them. So Texas is one of those wonderful states where you can choose federal or state. The reason why that's important is because federal allows you to keep cash, you can exempt it, and Texas does not allow you to keep cash, but you can cash in a bank. So that's why it is important to think ahead when you're planning your exemptions and decide which ones you are eligible for and which ones you want to use. Because in Texas, it does give you the choice of federal or state. It's one of those things where another way that you can show how wonderful Texas is. And I do love Texas for many, many reasons. So once you file your exemptions or your schedules, you list everything you own and everything you owe. And when you do that, you choose your protections. And the Department of Justice will appoint a private trustee to look over your exemptions and object on behalf of the creditors. Which creditors? Well, the ones that don't have any security in the debt. What types of creditors would that be? Well, creditor could be a credit card, like a American Express, Chase, one of those that doesn't keep an exempt. I guess you have to read the creditor. To the best of my knowledge, they don't keep a lien on what you buy. Unlike a house or a car, which is secured by the property, that being the house or the car. So you choose your exemption. The trustee examines the exemptions. They can object if they think that your honestly, I've been blessed in that the Department of Justice can come or have what I call the blonde lady come and take a look at your schedules if they have any questions, but it has never gotten past that. And they sit with you, with the trustee at the creditors meeting. And sometimes they have a question or something like that. And it never has gotten past that with any of my cases. They look at the schedules and the trustee will either say, well, that extra $2.04 that you had in your checking account, I want that check in my office. Or they can say, because it's not protected. Or they can say, we are going to abandon the exemptions. Other people, other creditors can also object to the exemptions. But the trustee is there on the benefit of the unsecured creditors. Then once that part of the process is over, you still have another hurdle to jump, which is that creditors can object to your discharge because they might consider that there was fraud. I call them the 246 or the to fraud, fiduciary, or willful and malicious injury. And that one is an interesting one. I'll get to that one a little bit later. The other thing that sometimes if you have thought of filing for bankruptcy and you're not quite sure of what the value is for an item, section, no, let's go without the section. But the formula is replacement value less marketing and sales, which can be anything from a car that it might be worth your while to have someone, even though you are the owner of the car and you can testify as to the value of the property, maybe someone else can also testify about the value of your property. And that it's another cost that would go into in addition to the legal fees that you can budget in. Another cost, if you have taxes, is you might want to take a look at the statute of limitations to make sure you file, if you have the luxury of doing that, you file once you have passed the age and condition of the tax returns. And there are a lot of software providers that help you analyze it. So that might be another cost. Another cost, of course, is the filing fees, which in a Chapter 7, if you don't have money to pay for the filing fees, you can ask the judge to waive the filing fees if you are at less than 150% of the poverty level. Or if you don't have all the money all at once, you can ask the court if they will allow you to make payments in installments. That is a very generous provision that only is available in a Chapter 7, the waiving. In a Chapter 13, you can have the fees, to the best of my knowledge. There is no waiver of anything. You can, however, pay them in installments. The filing fee for Chapter 7 is $338. The filing fee for a Chapter 13 is $313. And this brings me to another important point, which is you have to be very picky with your what you submit on your schedules. You have to make sure you list all your creditors and you have to list all your assets because it's under oath. So if you don't list all your assets, the court can, there are penalties, including jail, if you fail to disclose. So you want to be particularly careful that you don't forget. And some things are inadvertent, but that you don't forget to schedule to mention every little thing that you own, and also there is the extra incentive that the court has that if you want to add a creditor, it's $32 per creditor you forgot. So it sometimes pays to do a due diligence and get a professional credit report with all the liens and everything, so you don't have to pay more money to add more creditors when the application could have been complete at the time that you file. And well, if you forgot, you amend. But it sometimes, correctly or incorrectly, they get the court and the Department of Justice get the impression that you're being sloppy and maybe sliding onto untruthful, and so the neater your schedules and your property statements are, the better off you are. And of course, the rule is always, if in doubt, you disclose. You can, what are some considerations for in Chapter 7 or in Chapter 13? Well, in Chapter 7, even though you're disclosing, an asset might not be protected, in which case it's up to the trustee to decide in a Chapter 7 what they're going to do with your asset. In a Chapter 13, you can keep the asset, but you have to pay a portion of what the asset is worth. It's called the best, and it has to be included in the plan. It has to have, it has to meet the best interests of the creditor. So let's say the trustee in a Chapter 7 looks over your schedules. Nobody has questions, and you were very lucky that nobody objected to the exemptions or to the discharge. Then if you're in a Chapter 7, you still have another hurdle to pass, which is called the means test. The means test is they look at a formula that looks at what the IRS and the census say median income is for one person, 2 people, 3 people. And the Department of Justice publishes the median income and updates it regularly. So if you are failing the means test, which means you may have to go into a Chapter 13, you might be able to dig extra hard into your expenses as to why your food budget is so and so is such. I have had cases, not many, where I was able to find that the people had dietary restrictions or they were sick, and that kind of went over the amount that allotted for food, and was able to somehow lower explain why it was still on the they still did not fail the means test, because the expenses were allowed for food or for health reasons or something like that. But generally, the saying goes that pigs get fed and hogs get slaughtered. So I wouldn't go too crazy on that. If you have to file in Chapter 13 because you make too much money, or you're thinking about considering about filing for Chapter 13, well, if you file, or you stop working on that third job, if you're planning. If it's a surprise, yes, you file. And that would be the reason why some people also go into a Chapter 13 as opposed to a Chapter 7. Most of the reasons why people file for a Chapter 13, in my experience, has been because they're behind on their car or their home payment, and they need to set up a payment plan, and they have a regular income, and so they can make a payment plan and get the money from the plan to pay in 3 to 5 years, depending on how much extra money you make and how much of the items that you want to keep. Because sometimes, you might not want to pay extra for that boat, just money, return it, or sometimes people cannot afford to pay for everything, and so you can do a plan modification to take out the boat if the plan isn't working and you get behind. You can take some things out of the plan. Sometimes you have had the experience where someone wrecked their car, and so clearly the car was already until the insurance paid for the remainder of the car, but the person didn't lower their payments under Chapter 13 because now the creditor got paid some and might kind of lower the Chapter 13 payments. If you file for a Chapter 13 because you have regular income, you made too much money, you're behind on your payments for your car or your home. Sometimes you can also include other things in your plan. For example, domestic support obligations are never dischargeable, but domestic support property settlements can be included in the plan. I have read a lot of cases, and most of the cases the judges find that it really wasn't a property settlement, it was a domestic support obligation. But in those rare cases where the judge has found that, oh yes, this is a property settlement, you can include it in your Chapter 13. Other reasons why you want to file a Chapter 13 is because you want extra time to pay on your taxes. I did find an interesting case on willful and malicious injuries, which happened here in the Southern District of Texas, where generally, if the injuries for drunk driving are not dischargeable, injuries for willful and malicious injuries are not dischargeable, but the court makes a distinction between something that is negligent. Maybe you gave someone the wrong medication, and in result of your negligence, which is malpractice, the person lost 2 legs. But if the person in the course of a fight hit a person maliciously, the court found, because the court always goes behind, it's not called collateral estoppel. The court actually can look behind what happens, even if the case was a criminal case and it was no bail, for example, and say that the debt was willful and malicious. Even so, they take a second look. And in a case where someone gets shot in the leg, the court has found willful and maliciousness, whereas wrongly prescribing someone's medication and having the person lose 2 legs was not willful and malicious, it was just negligent. And if it's just negligent, it gets discharged. If it is willful and malicious, it does not get discharged. If I have found cases where one particular one was interesting to me, where a person had a bar fight, and the injuries for the personal injury were not discharged, but the property injuries were. And that's also the case with injuries when it comes to like a drunk driving accident. Something that can be the personal injury can be not dischargeable in bankruptcy, but maybe the property damages for the car could be dischargeable in bankruptcy. And so you have to kind of look and just take into consideration that it's the court that has permission to look behind the facts and take a look again. And that is done in an adversary. So sometimes you need to file an adversary to determine if a debt is dischargeable or not. And the bankruptcy court has the final say on that. And with that, I am done. If anybody has any other questions, you can ask me now. Well, the short-term and long-term benefits of filing are there. You have something called a stay of bankruptcy, which means when you file, it depends on how you're going to be doing this. Because if you file a case and you don't pay, then the creditor can lift the stay and take your property, because filing for bankruptcy is something that you do. So if you are going to file for bankruptcy and you want to keep paying on your car or your home, you continue to do so, and they really cannot take the car or the house away. However, if you are behind and you don't pay, or you don't propose a plan to pay, or you just the creditor will lift the stay and take the property. So the short-term filing, the short-term benefits of filing could be you get a reprieve in which you file. However, the creditors and the court have a limit on how many times you can file, let the case go and refile. And at some point, the court is not going to be too happy with how you're approaching, solving, and cooperating with the court. And sometimes life takes over. But in any event, the court is just going to say that you are not going to be allowed to refile the case, and that the case is going to be dismissed with prejudice to refile for a certain period of time. A person can file long-term benefits are, let's say you file Chapter 7, and after you get a discharge from the Chapter 7, you cannot get another discharge in a Chapter 13 for 4 years. But you are still are hounded by creditors. You can file a Chapter 13 even if you are not go and make the plan payments, even if you are not going to get a discharge, just because you have peace of mind. And so that is the long-term benefits. Can one spouse file for bankruptcy in a marriage and the other person does not agree? Yes, it's not a very good idea, because usually if you are married, the debts are supposed to be, I presume, to be just like if you are married and you have a child in the marriage, the children are presumed to be children of the marriage. Just the same way debts are presumed to be debts of the marriage. And so one person can file and decide that the other person doesn't want to file. If they live together, that's a really bad idea. I encourage people who live together to file together, but you can only encourage people, you can't make them file. So if one spouse files and the other one doesn't file, the discharge only applies to the spouse that filed. The creditors could, in certain cases, come back and go against the other spouse for what is considered community debt. So that is the reason why, especially if spouses live together, that both of them should file together. Any other good questions like that one or the other one? I may have forgotten to state. If I filed for bankruptcy a long time ago and did not include in it a creditor that put a lien on my home, so and those are called judicial liens, and that is one of the reasons why if my approach to this would be you file as soon as possible so you don't get a judicial lien on your property. But if you file and you file the way I would approach it would be I would file a motion to reopen, and then I would file a motion to avoid lien, and it's up to the court to reopen and allow a person to remove the lien, especially if it's a judicial lien that a person can. That would be my approach to the situation. Before I would try to file anything, I would just reopen the case and try to have, if the court allows, file the motion to reopen and then get the case dismissed. The lien voided. If not, in theory, there is a prohibition to discharge debts that could have been included in an old bankruptcy. That's why my approach would be first to try to file a motion to reopen, and I've even had to file one time a motion to reopen because the case closed before the person took the two classes that they had to take, the creditor education class and the debtor education class, and so they had to. I had to reopen the case and file. So you can reopen, and the court allowed me to do that. So the first thing to do, maybe ask the court. How long do I have to reopen the case? There is a case in California that I found that the case was reopened 12 years after the case had closed, and it was to, I believe, reopen to remove the lien and change the exemptions, and the court allowed it. So the longest I have ever seen a case be allowed to be reopened is 12 years, I believe, in Ninth Circuit. That is the best I know. I don't know in the Fifth Circuit if they have a different time period, but that was the longest one that I found. And I can look and see if the Fifth Circuit has any other prohibitions against reopening a case, but that is the best I know for today. Thank you. Thank you very much for allowing me to present. I hope that you learned something from this presentation. If you have any questions or concerns, please contact Texas Legal. And I want to thank Texas Legal for allowing me to have this presentation, and I enjoyed it. every time you try to present, you always learn something. And things like how long do you have to reopen the case are not things I usually look at. So thank you very much for having me. I had a great time, and I hope you did too.